Welcome, everyone. My name is Ryan Susky. I'm Director of Programs at the Ohio Center for Law-Related Education, and I'll be serving as the facilitator today for the Unit 4 hearing for Evergreen Middle School as part of the We the People National Invitational. In just a moment, I'm going to have the judges introduce themselves, followed by the students, and then we can begin the hearing. Students are going to deliver a 4-minute prepared statement, followed by 8 minutes of judge follow-up questions. Now, my microphone is going to be muted during the hearing, but I will be holding up the time cards. And so for that reason, I do recommend that you use gallery view so that you can see my time signals and of course your colleagues during the hearing. When the hearing finishes, judges will give some brief feedback to the teams and then we will conclude. With that, I'm going to hand things over to your chairperson to begin the introductions.
Well, welcome again, Evergreen. Good to see you again. We had so much fun talking to you yesterday. We thought we'd come back and talk to you some more today. We'll verify that no one's changed their name overnight and that you're still in the same school and we're in the same place, and then we'll proceed. My name is Joe Stewart. I teach in the Political Science Department at Clemson University in South Carolina.
Hi, everyone. I'm Diana Owen. I teach political science at Georgetown University in Washington, D.C.
Hi, I'm Deshawn Whitaker, We the People teacher in Charles County Public Schools in Maryland.
And you are?
Hello, judges. We're from Evergreen Middle School in Washington State. My name is Audrey Yang.
Hi, I'm Pranav Takrani.
Good morning, I'm April Shi.
Good morning, I'm Megha Ramachandran.
Hi, I'm Rachel D'Souza. Thank you.
Thank you. Well, as shouldn't be a surprise to you today that we're talking about question 2, and I'll read that question. It begins with a quote from the political scientist Robert Dahl. If a law has been properly passed by the lawmaking branches of the democratic government, why should judges have the power to declare it unconstitutional? Do you agree or disagree with Robert Dahl? Why? What is judicial review and why is it controversial? What has been the impact of judicial review on American society? Once the Supreme Court has decided that a law is unconstitutional, what power, if any, do the people have to change the Constitution? You may begin.
We are of the strong opinion that Robert Dahl was correct in his assertion that judges should not have the power to declare a constitutionally passed law unconstitutional. Judicial review was established during the 1803 case Marbury v. Madison and has since been upheld in numerous cases. It is the subjection of the legislature to the rule of law and has been ceaselessly debated. The argument around judicial review ties back to the issue of democracy and whether or not judicial review aligns with democratic values.
Supporters of judicial review maintain that a democracy practicing judicial review would constantly yield morally superior outcomes than one that does not. Advocates bring up an assortment of landmark cases that support their cause, notably Brown v. Board of Education, Lawrence v. Texas, and Roe v. Wade. This does not acknowledge that some constitutional rights have been devastated by judicial review, such as in the Dred Scott decision, which held that all persons of African American descent were classified as lower beings with no rights that the white man was bound to respect, thus invalidating a provision of the Missouri Compromise. Another would be the striking down of over 170 labor statutes during the Lochner era.
We criticize judicial review on 3 main grounds. First, the so-called need for judicial review to preclude tyranny of the majority is a defective argument. Second, judicial review does not promote citizen civic participation. Third, the legislative branch is just as capable as the judiciary in determining what is constitutional and what is not.
A common argument presented by supporters of judicial review is that as legislation is systemized with majoritarian parties, legislation is subject to tyranny of the majority. By that logic, judicial review is necessary to counter tyranny. However, this argument is inherently flawed because of the relativity of the posit. In any society that has differing viewpoints on rights, sides will almost always consider the other sides to be tyrannical. Pro-gun activists believe red flag laws to be tyrannical towards rights granted under the Second Amendment. Pro-choice advocates assume the pro-life position to be tyrannical towards women's rights. Although it is to be acknowledged that tyranny is certainly possible, just because a minority does not agree with the decision the majority has made, does not make their decision tyrannical.
Second, supporters of judicial review argue that if the Supreme Court overturns a law or statute, citizens still retain the power to overturn judicial review. They say this can be done through the election of representatives to Congress, as the rule of the Supreme Court can be reviewed by the legislature. However, this is indirect and not truly in the hands of citizens, meaning the general public has very little actual power to challenge judicial review.
On statutory matters, Congress may negate a Supreme Court interpretation by enacting new legislation. For example, Congress's 1987 Civil Rights Restoration Act negated the Supreme Court's 1984 decision, Grove City College v. Bell. Furthermore, Clause 2 of Article 3 makes the Supreme Court's appellate jurisdiction subject to Congress's, but this raises the point that Robert Dow brings up. Democratic legislatures are just as capable as the judiciary of determining whether a law is constitutional or not. Judicial review simply adds another unnecessary layer to it.
While we acknowledge that cases vital in shaping a fair society were made possible by judicial review, we still maintain that judicial review is undisciplined by the principles of political equality that are crucial for democracy to flourish, fundamentally agreeing with Robert Dahl. This concludes our testimony.
Okay, thank you. You've made the argument that the legislatures can determine constitutionality. Do they have different incentives or motivations than the courts for determining whether something is constitutional or not constitutional?
I believe that the legislature and the Supreme Court do have some differences in whether they determine a law is constitutional or not. And I would say that because legislatures are elected by the citizens, and they are from all different states. So, for example, a senator from Missouri, for example, will have different thoughts in mind when passing laws as a senator from, say, Idaho. However, when it comes to the Supreme Court, they are elected by the legislature and, well, not elected, they are rather confirmed by the legislature, and they are nominated by the president. And these Supreme Court justices, they don't, what they have in mind is their own thoughts and their own background and experience. They don't have an even mix of people from, say, the West Coast, from the East Coast. They don't have a racial sort of scattering amongst them, and therefore that makes them have different beliefs when it comes to laws and statute, when it comes to judicial review.
I agree with my colleague because like the judges aren't always like either like West Coast or East Coast. They're not right or left. It's like a mixture of all, but there could be biases because maybe most of the panel might be mostly right or mostly left. It depends on who you pick, and it could potentially like sway the opinion of many people.
I agree with my colleagues. The goal of the legislature is to best represent their citizens, whereas the goal of Supreme Court justices is to interpret the Constitution. So that is where the difference comes in how they deal with laws and judicial review.
So getting back to the issue of who makes up the court, do you think that the Supreme Court justices should be elected by the people, or that the system that we have now works?
Well, I think that the way that justices are nominated and confirmed now is honestly a little bit it doesn't relate to popular sovereignty, because just to reference in President Franklin Delano Roosevelt in 1936, when one New Deal program struck down another by like the Supreme Court, which was dominated by the Four Horsemen, or a group of very conservative judges. He even tried to manipulate the courts to increase the number of justices nominated. And I don't think that would have happened if it had come down to the people were electing the justice.
I agree with my colleague because I believe that the Supreme Court justices should be elected by the people, since the Supreme Court justices, we would feel better represented if they were elected by the people.
Actually, I disagree with my colleague on that part. I think that I might have misspoke. I don't think that Supreme Court justices should necessarily be elected by the people themselves, but however, the current system that is in place now, I believe, does have some flaws. I think that they should be elected using a bipartisan committee rather than having one executive member be nominating these justices.
All right, thank you for that. So let's stay on the idea of the justices being elected, and let's talk about their term. Do you agree that they should be on the bench for life?
No, I don't agree with that. Although I can't really think of something that would be off the top of my head, something that could replace that. I still think that the idea of having Supreme Court justices stay on that court for so long, which can still lead to packing of the court in some cases. For example, in the former President Trump's case, he managed to pack in 3 very conservative justices, although that may be stipulated as of now. However, the life term of the justices makes it very difficult for some kind of change to occur when it comes to changing the justices, changing the court's perspective, because as of now, the presidents are currently nominating younger and younger justices to ensure that they will retain the same verdict for as long as possible. Like the nomination of Coney Barrett, for example. Coney Barrett is a very rather young justices. Justices Gorsuch and Kavanaugh, they are also very young, and that can lead to inevitable packing of the court. So yes, I disagree with the point of life terms.
I would like to agree with my colleague. I also don't think that they should be on the bench for life, because in case there was like someone better coming in, then they would just have missed an opportunity. Like I think that maybe we should have a system like in sports, like they have like tryouts and stuff where they take a bunch of people and then they test them like all together. Like they could have some sort of tryout for them like every few years maybe, but I don't think they should have a beyond for their entire life.
I would also like to add on to that point that the Supreme Court justices, when they were nominated, as in the case of the former Justice Ruth Bader Ginsburg, she was asked by multiple people to step down so that the president could nominate a newer and younger liberal judge. And Ruth Bader Ginsburg, who I believe said this very correctly, but she said that was going against the entire point of being a judge. Like if she's able to serve, why shouldn't she serve? Why should she step down just so that there can be a longer liberal majority for, well, not a majority, but a longer liberal or a liberal court.
What about adding some qualifications? Right now, federal judges are the only federal officials that we don't have age and residency requirements for. Each of you right now is constitutionally qualified to be a federal judge. Could you see adding some type of qualification? And if so, what would those qualifications be?
I could see adding a qualification like they, well, to be a federal judge, you probably should have passed law school and passed the bar exam already and have been a lawyer for some amount of years. But obviously there are some like geniuses that are able to whiz through these proceedings very quickly. So I'm assuming that the age would be like the bare minimum would be 21, which would be the age for them to vote. But I'm assuming that the average age for a federal judge is around like 40s to 50s.
I would like to agree. Oh.
You can talk.
I would like to agree with my colleague that there should be some sort of minimum qualifications, because especially for a position that has so much power in a panel of only 9 justices at the moment and justices who serve for lifelong terms, nominating a justice is a very important power to have. So justices who are nominated should have to pass some sort of minimum requirements.
I would like to disagree on the age limit that Audrey stated as 21. I would like to up it to 30, because you have to have like some kind of background experience and like that kind of in the field experience as a lawyer. So yeah, I'd like to raise that one to 30 instead of 21.
Okay, well, we've run out of time, or otherwise we could get in a bidding war to see how high we could raise the age. So very good job. Well, thank you very much. I very much enjoyed the discussion we had where you're connecting the judiciary to the idea of democracy, and you gave us a good range of cases, the kind of standard Marbury, Brown, Lawrence, Roe, talked about the Lochner era, which is a good one a good discussion to bring in to the case. You're dealing with a really complicated issue here of how do we connect the idea of popular sovereignty to this branch of government where the founders went to great lengths to insulate it from popular sovereignty. I like the fact that you hinged a lot of your discussion on representation. You talked about it in terms of geographic representation, and having lived on the West Coast, I fully understand that. I joke with my students all the time that what is it that you're concerned about? We have attorneys from both Harvard and Yale on the Supreme Court, and we've now added diversity to the court with Georgetown and Notre Dame. But you're right, that's one of the things to deal with. You're also correct that the average federal judge is around 50 years of age, and you've gotten to some of the important issues here of how we approach this. So I very much enjoyed our discussion and thought you did a good job with it today. Thank you.
I also thought you did a really good job. You started out by agreeing with Dahl, and I thought one of the strongest parts of your prepared remarks was when you went and you had those 3 points about why judicial review might not be, your arguments are kind of against judicial review, and you went and elaborated on those and took a strong position. So I thought that was really well done. You started out, of course, with Marbury versus Madison and raised some important aspects of that, the idea of the rule of law and how this ties into democracy. And looking at the kind of moral superiority aspect of this issue, you, like my colleague said, you brought in some relevant Supreme Court cases at the right points in your presentation, and I thought that was really quite good. I also like the fact that you got back to Dahl. You started out by agreeing with him, and then you got back to Dahl toward the end of your prepared remarks to tie everything together. And I thought that was really quite good. I thought you had some really interesting responses to the questions. And I like the way that you brought up some key historical aspects of the Supreme Court, like FDR and court packing. I thought that was really a good point. And the idea of that I thought was very creative, the idea of having a tryout for justices. I had never thought of that before, but I thought that was really quite an interesting idea. I mean, you have people that show up on the Supreme Court. It operates in a very different way, oftentimes, than what in the lower courts, and I thought that was a really good idea. Also, the very sophisticated point about, Ruth Bader Ginsburg staying in there, even as she was being asked to resign, so that a younger, more liberal judge could be in there. And I, kind of thinking of the implications of that, by staying around so long, she, her seat went to a conservative afterwards. I'm not so sure she would have loved that, but you raised a good point there about kind of age and kind of playing that game to influence the composition of the court. So I thought you did a really nice job, and I enjoyed the conversation a lot.
Yes, I agree with my colleagues. I wish we had a little bit more time to discuss this idea of a democratic way to elect justices. I really would like to pick your brains about that and see what your thoughts are on that. I know we got a little piece of it talking about a little bit of the tryouts and the age requirement. And I just want to explore that a little bit further. But your opening statement was great. You did a really good job laying out the court cases and providing support for your thoughts and agreeing and disagreeing with each other as a team. You did very well with that and supporting your arguments with that. Overall, you did a very great job today.
I wanted to add something about the tryout aspect. The idea of getting the 40-yard dash time for each of the nominees, I think, is just so unique. I'll mention that to some people about the great idea.